Ms Foster.
My Lord, we were looking before the short adjournment at the case of Cotter.
We were.
Could I please invite attention to page 871 in the printed case, 874 e-reference, to paragraph 27, right at the bottom. I might be allowed to paraphrase, it's a paragraph that has attracted litigation interest and literary interest since it was decided. And I wonder if I might suggest the way in which the revenue reads the matter that was under debate there. We all know it says that that matters would have been different if the taxpayer had calculated his liability to income tax. But putting it rather crudely, if he had forced the figures into a place where we say they didn't properly belong. And what is said 3 lines down is, in such circumstances, the revenue would have his assessment that as a result of the claim, specific sums or no sums were due as the tax chargeable and payable for 2007 to 8. Such information and self-assessment would, in my view, fall within a return under Section 9A of TMA, as it would be the taxpayer's assessment of his liability in respect of the relevant tax year. The revenue couldn't go behind the taxpayer's self-assessment without either amending the tax return or instituting an inquiry. The way in which the revenue with respect read that is that as a matter of practicality, they would most likely seek to make an amendment. But we would suggest, particularly given the reading we invite you to give to sections 8 and 9, as well as 9A, which is dependent on those, in fact, in this case, the information does not properly fall within the return in the technical sense. It is not, in fact, included within the return in the sense in which we've been using that to say that it should find its place within the return for the year of assessment. And that, in truth, and as a matter of law, the revenue is entitled to disregard matters that are not properly considered to be included in a return, so that they needn't regard this as being properly included within a return and needn't give effect to it in the manner asserted, nor need they, in fact, technically amend it, we would say.
This doesn't arise in this appeal, does it?
It doesn't arise in this appeal, my Lord.
Right.
On a point of detail also concerning amendments, however, there is one, it may have been a slip of the tongue from my friend. I would just like to draw to your attention to correct if that was so. It relates to section 59 capital B, brackets little b, and you find that on page 616 in the printed case. My friend described 59b little 1 as the section under which amounts that had been amended under section 28A would be payable. In fact, we believe he must have meant under little 5, which says an amount of tax payable or repayable as a result of the amendment or correction of a self-assessment under, and then there's a 28A, as you will see given there. And something not material to my argument, but in case I said it, I wish to make it clear that it is not necessary on our case for year 1 to be final for a calculation based upon year 1 to have taken place. It requires only that it is assessed. And if I said something different, I apologise for that. I next have to deal with a point which is raised in my friend's case, where he asserts, because of our guidance, we agree that there is no effect upon the return for the second year of assessment. This is an extract from the manual that you find in the core bundle at 106.
Yes.
It is not to be taken as a statement of the Revenue's view of the law. It reflects practical guidance, effectively saying to the officer, do not go at once into the assessment and make an amendment. It speaks of the vast majority of cases, these are the first starred point, set off or repayment. In the vast majority of cases, that's how relief is given, and an increase in the aggregate amounts given. So they're speaking of the manner of calculation. It is not the case that this reflects the Commissioner's view of what the position in law actually is as to whether or not the assessment in respect of year 2 is in fact affected.
I suppose, what would be the effect of, if it was the Revenue's view of the law and it was inconsistent with your submissions? One's tempted to ask, so what?
Yes.
I mean, the Revenue doesn't decide what the law
Well, or indeed
means.
you, my lord.
Sorry?
Or indeed you, my lord, yes.
I think we do
Right.
decide what the law.
Yes, yes, I didn't.
Sorry, I wasn't very clear. No, sorry. No, well, maybe
No, quite
if
so.
I'm coming to the end of my time, perhaps it's about time I learned what we did.
No, I'm very, very willing to concede that my clients do not decide what the law means.
Anyway, thank you.
Yeah.
As a matter of interest, is it published, this manual?
It is now made available. It isn't published for the reliance of the public. It is an internal manual for guidance, which in the interest of transparency has now become available to be seen and used against counsel for the Revenue at every opportunity.
Good attempt to keep it secret, even if short-lived.
Yes. You have my submissions on the effects of Schedule 1B to bracket 3 and 2 bracket 6. We have difficulty understanding the submissions against us that 2.6 is no more than a timing provision. 2.3 appears to do the job that my friend says 2.6 must do on his analysis, and we say that it's wrong. Going back, if I may, to his case for a moment, I don't wish to repeat submissions, but just to indicate, we say obviously paragraph 12 in his case is wrong. Forgive me for not giving you an immediate
Don't worry, we've got it.
page reference. You've got this at page 68 in the paper, and I
69.
deduce 71 in the...
No, 69, actually.
Forgive me.
Don't worry, don't worry. No. We will finally have an appeal where there is synchronization between the electronic bundle and the hard copy, but
Not in my time.
no, not in my Lord's time, nor I has it even in mine, but
Really, our disagreement flows from the submissions that I have already made. And obviously, taking the point on further in his case to what is recorded on page 85, perhaps page 86 in the e-version, paragraph 39. We, of course, disagree, and I've explained to you the basis of the manual.
Are you able to venture a view as to what Schedule 2.3 does mean?
What it does,
Yeah, what's 2.3 all about? Is it simply about how you calculate limitation periods?
well, we understand that in fact it means any question about when the claim requires to be articulated is decided by reference to the later year. It's a claim that relates to it. One might have said a claim that properly belongs within it. Because this schedule is dealing with those claims for which a question might arise because they involve 2 or more years, it isn't immediately apparent to which year it properly belongs, and we would say the claim shall relate to the later year, means that the question has been decided that it is the later of the years in a case such as the present.
Yes. Yes?
Thank you very much. If I could take you then, please, to back to the core bundle at, I understand it's E89, and I have E86, paragraph, no, I don't, forgive me.
Which paragraph is it?
40, it's his case and little 9.
His case.
It's my 91 in my written case. I should say we have two versions of numbering in our written cases as well, but that needn't trouble you.
40 subparagraph 9.
Paragraph Roman 9.
Page 91.
I'm grateful. I have a note that that is E89.
I'm afraid it isn't, but don't worry.
It isn't, okay.
A93, I should know.
I see.
2, actually.
I shall give up and move on quickly.
Yes, just...
We inevitably take take issue with this. What he says in the last line, which is the submission that underpins the complications that are pointed to. The true point is that any amendment to the return or self-assessment could not impinge on the carryback loss claim, which is not part of the return. So the problems all stem from this initial proposition that it's never going to find its way into the return. There are a series of propositions that relate to that. Underpinning all of them, we say, and I needn't take you through all of them, is that misapprehension, which again is based upon, we say, a misreading of Section 8 and so forth. Likewise, I have 96, please, in the paper volume, E99, I venture, 41 brackets little 4. It's asserted that the Court of Appeal failed to appreciate an inquiry into the appellant's tax returns and inquiry into the appellant's carryback loss claims are inquiries into different matters which have different statutory effects. No, in year 2. It's very, very different once you appreciate what's being talked about is a year 1 and a year 2. The assertion there on behalf of the taxpayers is wrong. Same is true for what is said in 42. It is interesting, and we say characteristic of the nature of the submission that has to be made against us. On the next page, the last line of 42 brackets little 1 within his case, his first submission, he says, therefore the information in the return is only the information which is required to produce the self-assessment, in other words, the figures effectively. The word required is not a statutory word. It is the information. If insofar as he means by that, and he does, that it is confined in the way that, for example, a 0 figure is of no value, it is wrong, we say, and a misreading of the scope.
Yes, I mean, your position is in relation to your Annex 3, if X equals Y and Z was 0, you would say the result is exactly the same as it is in the example you give. Yes,
yes, indeed. I'm grateful. Indeed. His very last proposition on about the matter concerning the partnership agreement, which I shall deal with in just one moment, is written case paper 101. We understand at 44 that the real point taken, although it has developed somewhat this morning, that the real point taken is that because there's no effect upon I start again. Because the carryback loss claims are not part of any return, there can be no effect in the way that we describe, given what the statutory provisions do. Well, we say that that's wrong. I should perhaps introduce the contract point started as a submission from me in a judicial review case, that in any event, whatever the law position was, as a matter of discretion, the court should refuse relief because this agreement had been entered into a contract under statute. It developed then into a substantive point of its own, and you'll see how it was variously decided. What I say about it is that the real issue, part of the main submission, is that this takes effect under statute. And I would like to take you back, please, to the TMA.
Where do you want us to look?
Thank you. I'd like to take you back to 50, brackets 9, which you will find on the written case at 604. I understand that's E607, in fact.
Yes.
Procedure on appeal. It explains what happens if there is an appeal. There was one in this case, but we know it was compromised. It compels, as a matter of statutory effect, if on an appeal it appears to the majority of commissioners by examination or other evidence that the appellant's overcharged, the amounts contained in the partnership statement are excessive and so forth, the assessments or amounts shall be reduced accordingly. Otherwise it stands. And then further down at 9, where any amounts contained in a partnership statement are reduced under subsection 6 above or increased under 7, officer of the board shall by notice to each of the relevant partners amend the partner's returns. So there is a statutory effect if an appeal takes place with those consequences. What happened is just over the page, at next page 54, settling of appeals by agreement. So that's the context to what happened. And the point about this is that the paper that we have, this agreement, reflects an agreement under 54.1. The first two sentences I needn't read out, whether in writing or otherwise, that the assessment or decision under appeal should be treated as upheld without variation or varied in a particular manner or as discharged or cancelled, the like consequences shall ensue for all purposes as would have ensued if at the time when the agreement was come to, the commissioners had determined the appeal and had upheld the assessment or decision without variation and so forth. And we've just seen what those consequences are. So what the context to that particular agreement is that it takes effect under statute, and it has the effect of making amendments in, as it were, the very instruments, the very documents that evidence the claim or the amount of claim available. The point about this is it was a partnership appeal, and what it was about was the amount of available loss. That is what this agreement determined, how much loss is available to the partners. There's only, I'm so sorry.
Sorry, no, don't let me interrupt you.
There is only one amount of loss. It is distributed, as we know, according to the partnership shares, but it's the same loss that's being talked about.
Yes, as I understand your position, you don't need to get into the Partnership Act at all because you have you have an inquiry into the partnership return, which is a deemed inquiry into the partner's returns. You then close the inquiry, and in that context, Section 28B(4) entitles you to amend the partnership returns. If that is then appealed, if the actual inquiry is appealed, then you have the result that the settlement is deemed to be the equivalent of a first-tier tribunal determination.
Yes.
And then Section 59 is really the equivalent of 28B(4), that you can alter the partner's returns.
You can do so, yes. which I suspect is why my friend approached it on the basis, well, we say that you're not in that territory at all.
Yes, but I think his point only runs, I think he recognised that, if he'd succeeded on the earlier points.
Yes. Yes. We do also say, and I shan't take you to it, but I would respectfully invite attention, it's paragraphs 42 to 44 of Lady Justice Gloucester's holding within the Court of Appeal decision, where she analyses it as a matter of partnership law. We say that those are the submissions that we would make to you in any event, and that were that necessary, in other words, if my argument about the statute is not a good one, and I need to say more, we say that in any event, it's perfectly clear that this was binding in the way that we say it was upon the losses for these partners. And there's no daylight between the fact that it was the general partner who, as he might, bound the partners by what he entered in the form of that agreement. There are one or two matters that are raised by the intervener, which, in fact, the submissions that I've made, we think should make an end to those points, insofar as we understand that it's put very much on the basis of not being able to affect the self-assessment for year 2. You have all my submissions on section 8. And to the extent that her submissions rely upon that, we'd respectfully say that they should fall away. Her conclusion is the same as that of my friend. We say it fails for the same reasons that his do. There are provisions within the sections and the schedules that I've shown you that are inconsistent with those arguments. And insofar as we understand the point that is made about giving effect, it is not the case, on our argument as we've shown, that it is not possible to give effect to amendments that might be made or changes made in the result of a year 2 position as we advocate it to be. We don't understand that there are any further submissions on that point, but would your lordship give me a moment just to see if there's something else I should be? My learned junior helpfully suggests that I should show you 1B at 2.6 to make good the point about giving effect. And you will find that on page 668 within the printed case. I hesitate to say 2 or 3 pages either side of it. We're looking to reorientate ourselves on the previous page in that schedule for claims involving 2 or more years. And what 2.6 tells you is effect shall be given to the claim in relation to the later year, whether by repayment or set-off, or by an increase in the aggregate amount given by section 5.1b of this Act, or otherwise. So a number of manners of doing it. There is no need in this for reliance upon the freestanding credit or the notional account, although as a matter of practice that may happen. My lords, was there anything else that you wished me to deal with?
No. No. Thank you very much indeed, Ms. Foster. Ms. Nathan? Yes.
Take one, I'll bring the other.
I would have thought the Supreme Court might be able to run to more than 2 lecterns.
Great opportunity for donation to the furniture.
That's very generous of Lord.
Yeah. Maybe Court 1 has more lecterns than Court 2.
Yes, or maybe they have none. We've got the only 2. I don't know. Mr. Ewart.
We agree, the appellants agree, that the critical question in this case is whether the claims are capable, and I quite happily adopt the word capable, of feeding into the calculation of tax for year 2. We say the answer to that is simply no. They're not capable, and they never do for that reason. If you go back to my example of the 3 years, the tax which was chargeable and payable for year 3 in my example was 0, you remember. That would have been exactly the same if the taxpayer had not made any claims to carry back losses to any prior year, but had simply carried forward the losses. The amount of tax chargeable for that year would have been exactly the same. It would be 0. It would be exactly the same if he made the claims, the revenue inquired into them, and then amended them to 0, and that was upheld by the commissioners, the first-tier tribunal. The answer would still be 0. And that's not, it's not simply a magic of 0, choosing 0. Whatever amount of tax I had chosen to be chargeable in year 3 from other income would have remained exactly the same. Whatever carryback claims were made, whether they were made or they were not made, or they were made and amended to 0 or amended to some other figure, it would always be the same.
Can I just ask a question on that? What if the claim meant you're entitled to a certain amount of relief, and the relief was given by being set off?
Yes.
Would that not then reduce the amount of tax chargeable?
It doesn't. No, it doesn't. But it sets off what you have to pay, but that does not affect the self-assessment. And that's why I showed you what the revenue said in their manual on page 106.
Yeah.
And I would adopt that as being correct as a matter of law. And with the greatest respect, it is intended to be a statement of the law. It may have been a statement of the law for the revenue's benefit, but it's definitely a statement of the law. And I'm going to come back to that because there was a further point made in that, but it doesn't affect the self-assessment. It means that you have your self-assessment, what you have to pay for the year would be £50. You could then discharge that liability by the set-off, by using the credit. Just as if you discharge the liability by using by the payments on account, that doesn't reduce the self-assessment for the year. That's simply a means of paying the tax that is due for the year. Your payments on account are then set off against your liability for the year, the amount of tax that's payable. But the self-assessment, is very important to understand this, the self-assessment is fixed and isn't affected by whether the tax is paid. You couldn't possibly say because you sent a cheque to the revenue that your self-assessment became 0. That would be nonsense, obviously. That's not how it works.
But you say a sideways claim is different.
A sideways claim is quite different because that does feed into the calculation of tax chargeable and payable for the year, because it reduces, in the computation of the tax chargeable, it reduces the amount of income or gains or whatever that you have.
Yes.
So if you have 100 of loss of trading loss and you have 100 of trading income, you claim to set 100 of trading loss against 100 of trading income. You therefore have 0 income for the year. Your self-assessment will be 0.
Yep.
That's the difference between the two. And the reason for the difference is because, as I explained at the beginning, it's easy to deal with sideways claims because they're all in the year. They're all part of the assessment for the year. Carryback claims are much more difficult to deal with because unless you have a system as they've designed here, you end up having to keep the earlier year open to attempt to give the relief in the earlier year, which is what you used to have to do in the past. What they used to do was actually...
The effect of the carryback credit, whatever it turns out to be, is analogous, you say, to a payment made on account.
It's the same, yes. It's a token that you have. You can cash it in various ways, and that's how the revenue explain it. And it's freestanding in the sense it's not linked to any particular year. You can use it against any liability to tax or to obtain repayment of any tax from a previous year.
If you're right about that, does it not? Why does it not then come within the scope of Section 8 as bearing on the amount payable by the person? You know, I mean,
For the amount payable for the year.
yeah,
No, but that's not the amount that you have to pay in tax. That is the amount payable for the year.
Chargeable means chargeable.
Chargeable.
Means chargeable, does it?
no.
No, it means
what it
means
says.
payable. It means payable for the year, but that doesn't change if you pay it. I mean, I'll give my example. If you have an amount payable for the year and you send a cheque to the revenue, that doesn't reduce the amount payable for the year. It's remained the same. The amount payable for the year was 100. You've paid it, but it doesn't affect the amount payable for the year.
Yes, I see.
So, I mean, for example, we're told in Section 8, 1AA(b) that the amount payable is the difference between the amount chargeable
Yes.
and the aggregate amount of any tax deducted at source and any tax credits.
Yes, precisely. That's the definition of the tax payable, and you don't take account of anything else in working out what's tax payable. You take account of what's chargeable, and you take off what you've paid in advance by deduction or by way of tax credits.
Right.
And that is the tax payable. And that goes into the amount you owe the revenue column. And you can then discharge that by various means, sending them a cheque or by paying electronically or by making use of a credit that you're given under Schedule 1B.
Mm-hmm.
Yeah. But that is fundamental to the self-assessment system, I think, the way it works. So given that, and I would submit that's clearly correct, the question is, in what sense are these claims capable of feeding into the calculation? And I think the only sense that my learned friend put forward was her Annex 3 idea, which is it feeds into it in the sense that you might need to know the total amount of carryback claims in order to check whether the taxpayer is performing his calculations properly. And that's the significance, my Lord Hughes, I think, asked, box 416 in the return. That's what box 416 is. It is checking the arithmetic. It's making sure that you haven't made a mistake, most likely, and the amounts that you've claimed to carry back and to carry forward, etc., they must match the total amount of losses, arithmetically. And that's the reason for having box 416, just to ensure that's the case. But I would still repeat my submission that that is not in any way a provision which allows you to make a claim to carry back losses. The loss has to be returned, and I don't know if there's any confusion about this. There's no doubt the loss has to be returned in the return, because that is the result of the business that you're carrying on. But we're not talking about the loss, we're talking about the claim. Now, the revenue seemed to accept, my learned friend accepted, that a standalone claim made, let's say, before the end of the year of assessment would fall within Schedule 1A. And she's explained that the reason for Schedule 1A was to allow the revenue to give relief earlier than otherwise would be possible. And it may well be right that part of the rationale behind the system is to allow earlier claims, but that is not a point really which goes against our case or goes in favour of the revenue's case. The point I would make is that the revenue do accept that they can give effect to these claims, presumably under paragraph 4 of Schedule 1A, or they can inquire into them. It must follow from that these are claims, and they are complete. The revenue wouldn't have the power to give effect to them if they weren't claims within Schedule 1A. But somehow they also say the claim is somehow conditional on making the claim again in the return. And I don't understand how that can be squared. I would submit that just doesn't make any sense. If the claim must be made in the return, as the revenue continually repeat, how can they give effect to the claim? And what would happen if you didn't put it in your return? So you made the claim in a letter, they gave effect to it, and then you didn't put it on your return for some reason. Would the revenue then be able to say, aha, the claim has now become invalid because you haven't put it on the return? You must pay us the money back. There's no provision for that in the legislation, simply doesn't work in that way. This claim simply is not part of the return system. The other way of getting there, I think that your lordships were quite attracted to this, was paragraph 2.6. That the effect of that, even though it doesn't feed into the self-assessment or the amount chargeable, that somehow that means you have to return it for the year. But that would lead to a very peculiar situation. The draftsman of paragraph 2 on this hypothesis would have introduced a provision in subparagraph 6, which means that the claim must be included in a return. That's what's being said.
Yeah.
But at the same time, he's put a provision in subparagraph 2, which disapplies section 42.2, which says that you have to put a claim in a return. Now, if that's right, that would be a brilliant trick by the draftsman. He's made out as though you don't have to put it into the return, but actually he's tricked you because, in fact, by paragraph 6, you do have to put it in a return. I mean, that just isn't the way that Parliament, legislation is drafted. Paragraph 2, sub 2, specifically disapplies section 42.2. The only inference you can draw from that is that it's not intended that these claims should be required to be put in returns, made in a return. There's no other sensible conclusion that you can come to. Well, then, for instance, why is that there if you wouldn't fall within section 42.2 anyway? Well, that is an interesting argument that you can have. Why is section 42.2 there in the first place? But all of this is sophistry beyond belief. The revenue are being forced into incredibly sophisticated readings of the legislation in order to justify the fact that they simply didn't open a Schedule 1A inquiry, which is what they could have done. There is no lacuna in this legislation. There's no problem. If there were a glaring lacuna which needed to be filled, I could quite understand submissions of this sort, how you construct the legislation, but there is no lacuna in these provisions. As regards Cotter in paragraph 27, I would simply repeat what I said earlier, that it isn't relevant to this case, as Lord Reid said, but it's clearly correct that a self-assessment, even if it's wrong, is a self-assessment and it's within the return. Section 9 tells you, I think, that. And therefore, it would clearly be open to the revenue to open an inquiry into the return. But if it didn't do so, then the self-assessment is final and conclusive. And as I say, that's what happened in a number of cases. Can I then take you to section 59B? This is an important provision.
Yes.
It's on page 616.
Yes.
619 electronic. Authorities bundle.
Yeah.
And it wasn't a slip of the tongue. I did intend to say that subsection 1 is a section which imposes a charge or the liability to tax when a self-assessment is amended. The reason I say that is because the amount that is produced by section 59B1 can change depending on what the self-assessment says. So it is one figure when you put in your return and the self-assessment, but it might change to a different figure, a larger figure, when the revenue amend your self-assessment. And subsection 5 tells you when the difference between those two things becomes due. But I would submit it is actually subsection 1 which imposes the liability to pay. Mm-hmm. And it follows from what I said about at the very beginning of my reply, that the claims do not affect the amount chargeable or payable, the amount of the self-assessment, that amending the claims cannot have any effect on the amount that you have to pay under Section 59B, because amending the claims will not alter the amount of income tax contained in the person's self-assessment under Section 9. That will always remain the same. So the amount of, in my example, going back to my example again, the amount would have been zero, and if the claims were amended by the revenue down to zero from 75, the amount in the self-assessment would remain zero. So there would be no liability to pay anything generated by Section 59B. So as I said in opening, even if the revenue are right, that somehow they can amend the claims because they're in the return somehow, it cannot generate a liability to pay. And I would submit that that is a strong indicator. Well, it has two effects. One is a strong indicator that the revenue is wrong in there. But in any event, it means that Mr. De Silva, in cases where there's been repayments, there is no statutory authority for the amount to be paid by Mr. De Silva.
Can you explain to me what was actually going on in the amendments that were actually affected? If one looks, just by way of example, at page 350 in the paper version of the core volume.
350, my lord.
Yes, 350.
Yep.
There are a few examples in the bundle. They're all in the same form. This one's addressed to Mr. De Silva, and it's telling him that the appeal has been settled under Section 54, that consequently his allocation of a partnership loss has been altered. The writer says, I'm now amending your own return oblique or carryback claim to reflect this change. I've enclosed details of my calculations. And what one then sees, one goes on to 352, is first of all, what is headed up tax calculation for the relevant year.
Yep.
We have the original loss for one of the partnerships and then the revised loss, the original loss for I think, another partnership and then
Yep.
the revised loss. And then how I calculated your income tax. And what I think is going on here is the first line, which produces the figure of 22,400, I think is the original calculation of the loss relief.
Of the freestanding credit.
Yeah.
Yes.
And then the revised loss relief is based on the amended figures.
Yeah.
Then there is the difference between those two figures is calculated at the 17,000 figure,
Yeah.
which is the total tax due. And then one sees on page 2, 5 line down, what happens next? Please pay 17,000 by a specified date. So it looks as though he must have been, I assume he must have been
He was repaid.
repaid.
I thought that was, yes. He was repaid 22,400.
Yeah,
And now they're saying he should only have been repaid 5,223.
yes. So effect was given to his original claim in relation to what we've been calling year 2 by repayment.
Yes. That was pretty closely after the claim was made, I believe. There was
Yeah.
a repayment made.
Yes, I see.
So effect was given to it. And what the revenue are purporting to do, and we say this is not lawful, they don't have the power to do this, but what they're purporting to do is to amend the claims, the carryback claims, to the lower figure, and then to say, well, you have to pay us the tax, the difference.
Yeah.
And we say there's two flaws with that. One, they can't amend the claims, and two, even if they can, there's no authority to demand the tax.
Yeah.
Yeah. But the fact is that they did give effect to the claims. I think my learned friend accepted that the revenue do accept that these claims, they do give effect to these claims.
Heard from her about the about the effect of the letter.
We should ask Alison Foster about the terms of the letters. Yes.
Yeah.
So you would, you would say, would you, that the tax calculation, both the original, we don't, I don't think, I'm not sure we have the original one, but the original return should have had in it, from section 9, a calculation of the self-assessment.
For year, which year are you talking about, my lord?
Well, for example, the figures we were just looking at were a tax calculation for 2006 to 7 for Mr. De Silva. And
I'm sorry, could you just remind me what page it was? I think
that was 352.
352, right.
I don't know if we have the original statement, return or not, but presumably the return will have, I'm just trying to think this through, the return will have included a self-assessment. And
This is for the later year you're talking about, or the earlier year?
yes,
The later
yes,
year,
the
yeah.
one for the later year.
It would have been a self-assessment, yes. But it wouldn't have included any of these figures. The calculation, of course, the carryback loss relief calculation is based, as you've seen, on the earlier year.
Yes, the calculation is based on the
Loss relief is calculated on the basis of the earlier year.
Yes, but he must have, presumably he got the repayment of £22,400.
Not from year 2. In fact, he got the repayment before the end of year 2, so well before the return was put in, factually.
Yes, and so he must have submitted a return for that year, which brought out as his self-assessment. Correct me if I'm wrong about this, but I'm assuming he will have submitted a return for that year, which will have included a self-assessment, and the self-assessment will have brought out a figure payable to him of £22,000.
No.
No, right.
No. His self-assessment for the second year, for the later year, would simply have been his income for that year and the tax due on that income. That's all. It wouldn't have included any of this.
And so at what stage?
These figures, anyway. It wouldn't have included these figures.
But at some stage, he has made a claim based on the original, the originally claimed losses.
He made the claim, I think, he made the claim quite early, as we know, and I think effect was given to it, my recollection, something like the 1st of March in the year. So it was well before, even before the end of the year of assessment. And then he would have put in his return for that year. He'd have claimed he got repaid, but he was being repaid tax he paid previously, not tax for that year. He's been repaid tax he'd paid previously because of the freestanding credit.
Yes.
And then he put in his return for year 2,
Yep.
and this wouldn't have appeared in the return. The figures wouldn't. What would have appeared is his income for the year and the amount of tax he had to pay on the income. And of course, a figure of 0 would go in for the loss, because into the computation of his income for the year. But this wouldn't have been any part of it.
So when he made, what's the assumption that the claim was made by letter?
Well, I think the claim was made, in fact, in the tax return for year 1, in the form.
Right.
And given effect as a freestanding claim. That's what actually happened in these cases.
Yes, I see. Yes, and so he's not within Section 42 because he's making the claim before he's actually received a notice for the relevant year.
Well, that would be the case as well, but of course, even if it had been afterwards, the taxpayer would have understood that he wasn't within 42 because of Schedule 1B, Para 2.2.
Yes, I see.
It happened that they made the claims in the year 1 returns in these cases, but in other cases they might have made them by letter later on. I don't think anything turns on the precise timing.
Right, thank you.
But the point is it wouldn't have affected. It isn't tax for year 2. I'm just trying to get this across in any sense. Can I just take you to to the manual bit, because there's another part, which is, given the way the argument's developed, is interesting. This is page 106 we were looking at, about self-assessment, the fact it's not part of the self-assessment. But if you turn back to the extract before that, Annex B, which is Self-Assessment Claims Manual, that's discussing paragraph 2.6 of Schedule 1B and how effect is given to the claim. And they discuss the various things: repayment, set-off, an increase in the aggregate. And then they say at the bottom, you'll see, it's difficult to see what's meant by otherwise, and they talk about that. But then over the page, to the top of the page, you see paragraph 2.6 does not say that you give effect to the claim by adjusting the self-assessment for the later year, which we would say is absolutely correct. We would adopt that. The only relevance of it, my Lord, answering Lord Newborough's question, is that I'm adopting what the revenues say as my submissions. Mm-hmm. It doesn't say anything about the self-assessment for the later year. So I was just going to finish then on the agreement point. My learned friend was arguing that the agreement takes effect under statute and Section 54 is relevant. We would say that's simply a complete red herring. The argument would be the same from the taxpayer's point of view if the case had been heard by the first-tier tribunal, or the special commissioners, depending when it was heard, and been determined in the revenue's favour in these terms. Because all that would have done would have been to affect the partnership return and the individual partners' returns. And if we're right that the claims are not part of the returns, then none of that would have had any effect on the.
But how do you get around the provision that there's a deemed inquiry which is opened, which gives rise to a result that involves an alteration of the individual taxpayer's liability, and if there is a determination by either settlement or by the first-tier tribunal, then there can be automatically an alteration of the
return.
Of the return.
Yes, well, that's the whole point, though, my lord.
You depend on the argument that it's not in the return.
It's not part of the return, of course.
But I mean, if it's not part of the return, the agreement argument doesn't arise. You would say.
I say the only time we have to look at the agreement argument is if we're right, because if we're wrong on the first points, it doesn't matter what the agreement says. We've lost the case. If we're right, the only time it becomes irrelevant is if we're right. And if we're right, then it doesn't help the revenues, what we say. It cannot affect.
It's an argument that can't run either way. I mean, if you're right, Section 54 doesn't help the revenue. But if you're wrong...
If I'm wrong, it does, and that's the end of it. Yes, if I'm wrong, I'm wrong. I'm wrong twice. That's fine. But I don't see any point in arguing the case on the basis I'm wrong about the first point, because it's a rather academic argument.
Capacities without
yes.
getting involved in that.
So the only argument is if we're right about the first point, does this have any effect on our personal claims outside the returns for carryback of losses? And we submit simply it doesn't. And it would be very extraordinary if it did, since it doesn't purport in any way to deal with partnership rights that individuals have in making claims, which by hypothesis have crystallised already, and they have these rights.
It doesn't purport to deal with your right to carry back, obviously.
Yes.
It depends on the individual circumstances of each partner. It does purport to deal with how much is available to be carried back, doesn't it?
It does, but only if the revenue are right, that there is a link somehow between the return figures and the claims. Because if they're right about that, then it would affect it. If they're wrong about that, then the individuals have these rights which are unaffected by the returns, unaffected by what happens to the returns, unaffected by the partnership litigation. And we would submit it's impossible for that to have been determined. What basis would the revenue have? Are they saying as an estoppel or something? But the problem with that, of course, is that in 2011, when they entered into the agreement, the taxpayers already had these rights. There was nothing the revenue could have done at that stage to have changed things in 2011, because they were well out of time for any Schedule 1A inquiries or any assessments or anything. So there's no question of detriment to the revenue at that time. So there was no kind of argument on the basis of an estoppel or something like that. It would have to be that this agreement overrides their statutory rights without having referred to them anyway. Unless I can assist any further, my Lord, those are all my submissions.
Thank you very much, yes, Stuart. Well, Ms. Stewart, Ms. Foster, thank you very much indeed for your submissions, which we've... Well, yes, okay. Yes. Yes, I was wondering whether you wanted to explain how the agreement operated, the agreement of the, or the letter.
What I'd be interested in is the mechanism that you say the revenue can carry out to give effect to what you say is the disallowance or the reduction of the claim. How do you alter the return?
Yes, sorry, I was missing the point. Thank you.
How do you physically alter the return? I have some instructions on this. It is, from memory, it is box 4.2. No, I shall do it more precisely and find my note.
Let's find the
Yes.
document. Sorry, it was cross purposes. Sorry. Which form should we be looking at? We were looking at 389, tab 17. Is that
389.
the right thing, or is it somewhere else?
Your Lordship, forgive me while I take some instructions.
Of course, very sensible. Yes, Ms. Foster.
Very grateful to those behind me. Page 389,
Yes,
box 4.7, currently says loss of 35,000.
yes.
Whatever the amended allocated loss was for this person would be placed in that box. That same figure would find a place in 4.14,
Yes.
allowable loss. Then, on the assumption of the proportions that were reflected there, loss to carry back would be amended in 4.16 on the basis of that.
Yeah.
Yes, but how does that then, how do you fit those alterations into statutory authority to charge?
If you pick up 59B with me, please, page 616 on paper,
Yes.
which expresses the power to charge and how it's calculated. As we saw, 59B1 says how you do it, what you net off. After 1, it says, there's little a, little b, shall be payable by him, or as the case may be, repayable to him, as mentioned. Then, if you please follow down to 5, an amount of tax which is payable or repayable as a result of the amendment or correction of a self-assessment under section 28A, which will be us, amendment or correction of return under section 8 or 8A of this Act, or, and they give the partnership provisions there. Then you have a date by which you must pay, which will be set out in Schedule 3ZA, which I can show you.
Yes, I know that, but...
Forgive me,
I've
I'm
seen
something.
that, but 59B1 says that what is payable is the difference between, and I'm only interested in the top line,
Yes.
the amount of income tax and capital gains tax contained in the person's self-assessment.
Right.
What I'm wishing to understand is how does the amendment of boxes 4, 7, 14 and 16 affect the amount of income tax payable contained in the self-assessment?
Well, an amendment of the partnership return
Yes.
causes an amendment of the partner's return under 12 AC, I believe, 6.
This is where 12...
Give me while I find the right.
Page 552,
Grateful.
is that right?
Being the notice of inquiry.
That's a notice of inquiry. Is it 12 ABA on 551? Twelve ABA
Yes,
3.
I'm grateful. It is ABA, I was wrong. It's,
Is it 12 ABA 3, or was that wrong?
I think, no, it's fine.
That's the partner making the amendment, isn't it?
Yes. No.
Yes, it is.
When the partnership returns amended.
Maybe I've misunderstood.
Maybe that's wrong.
Partner.
It is 12AA, maybe, isn't it? But that's by the taxpayer.
Well, the partnership return can be amended on 12 ABB.
I think I may be following
It's AB.
something, having
Is it ABB?
misunderstood your
Is it
question. my
ABB?
lord.
It's ABB 6, I think.
It's ABB 6, I think, which reflects ABA 6, ABA 3.
This is when we do it, ABB.
Yes,
I'm
12
grateful.
ABB it is.
ABB is when you do it, and ABA, I think, is when they do it themselves.
Yes.
Is it that my lord was looking for?
What I was looking for was to
Where
understand
you get the money.
how in practice the revenue give effect to your interpretation of the legislation, and in particular in 59B1, where do we find the amount of income tax and capital gains tax contained in a person's self-assessment? Where do we find that being altered by virtue of the revenue theory?
Well, we understand that 5 does that for us, because the amount of tax which is payable or repayable, which as a result of an amendment, in other words, the way in which the amendment alters whatever was previously the amount, will produce, it gives a power to require that amount to be paid, is payable. So whatever the amended amount is,
Yes.
following on from the amendment.
Where is the amendment made to the self-assessment to give rise to the 59B1A figure?
Yeah.
What are we altering other than 4.7, 4.14, 4.16 to?
Yeah.
I am being very foolish, I'm sorry. The document that we're looking at is the return for the
Yes.
partners. We've seen the section that then causes an amendment, amendment of like effect to be made on the, sorry, it's the partnership one, the one I was taken to, the 389. We then see the effect being reflected on the partners document.
Yes.
And the sum will necessarily, given the effect of 59(1)B, which shows you how to calculate, and then when you've got a calculation, what you do about making the amended amount payable, which is 59B5. So you will, having amended the partner's return as a consequence of the statutory mechanism, be producing for the partner a sum which is different from the one that would have been there before on his own
But is there a particular box in the partner's return that would be amended to achieve this? That's what I'm trying to understand. Ultimately, we must decide it on the basis of the statutory code, whatever the revenue has done in its administrative forms. But what I'm trying to see
Yes.
is, what do you say in the partner's return is altered to implement and give rise to the 59B5 authorisation to tax?
It may be communicated by letter, but it becomes this part of the self-assessment, because what it does is reflect the calculation that's been amended, is my understanding. So there will be a calculation carried out, and as it were on the computer, because of course it's all done by computer, in addition to the pages, if another page is needed, then the page that carries out, has the calculation set out, will become part of that self-assessment.
So the revenues letter is treated as their calculation?
It becomes part of it, in the same way as there are other sheets that we don't have here that you may or may not use. So something that feeds into it, that is properly part of the assessment, is the assessment.
Yes, because one can sometimes have the form, and you can also submit a tax calculation with the form, which isn't what the revenue have produced, but it is something showing.
It becomes part of the
But
self-assessment.
that becomes part of the self-assessment. So you say the revenues letter, to which my colleague Lord Reid referred, is treated as part of the self-assessment.
I'm instructed that it is, and that is physically, or practically, I should say, what would happen in a case like this.
Yes.
Is this form that's at 389, does it begin at 365? It's all the same thing, isn't it?
That rings a bell, I believe it does.
And it's not a partnership return, it's Mr. Dockelman's personal return, isn't it?
It is.
And
You're quite right,
it's
part of
got
the
it's got at the back of it 389 and otherwise and similar, which is headed partnership short, because Mr. Dockelman was a partner.
Yes, it reflects his share of the partnership losses.
Right. Now, where in the return does he make what you say is a claim for the carryback? Is it at 373?
373,
Yes.
well, as we understand it, yes.
Yes.
The additional information.
The losses shown on the partnership forms are to be used as follows: 133,000 for 1 year, 125,000, 122,000 for another.
Yes.
So you say the letter supersedes that. So the letter is additional information, like that different additional information, and supersedes it.
So,
It acts as an amendment.
so we're back to the question of whether it's a claim or not. If that's a claim, you can amend it. If it isn't a claim, you can't. Is that it?
On the facts of this case. If my friend is right, we can't amend because of his argument about it requiring to be in the return.
Yes.
To which you have my submissions.
Yeah. Whilst you're on your feet, can you just remind me of where in your document do you deal with the what is said to be a separate alternative contention, that even if he's wrong about his principal point, you can't get the money back from Mr. De Silva? Because he does say that, doesn't he?
Well, I understand that point to be the one that I had answered, insofar as if he's right about this point on assessment and I'm wrong, he's saying you've no statutory power
Yes.
because you can't operate 59(1) because it's assessment dependent.
It's simply that, yes. Okay.
That's how I understand the point made against me.
Thank you very much.
If you still have the tax return in front of you,
Yeah.
we were looking on page 373 at the additional information box. And you'll see that we're told there that the losses shown on the partnership forms are to be utilised as follows, and then there is a carryback of of a figure to 1999-2000, and a carryback of another figure to 1997-98. And we're told that what the tax reclaimed amounts to, and there's a reference to box 18.5, and we'll find that on page 370. And there, if you look at 18.3, we're told there what the amount is of the total tax, NIC, and etc. For the year of assessment, the current year of assessment, before making any payments on account. So that's I know we have a figure for that. So that's effective. I mean, would it be fair to say that that's the sort of that's effectively the gross amount of income tax chargeable before you start taking into account any reliefs, any payments to account, and so forth?
Yes, he's putting in the one side of the equation, if you like.
Yes, and then if we go down to 18.5, that's to be ticked, and it is ticked, if you've calculated tax overpaid for earlier years, and the amount is entered in the additional information box, which we just looked at. And then the so that's where the figure in the additional information box for the amount of overpaid tax being reclaimed comes into the current year's calculation, I think.
Yeah.
Yes, and the amount payable.
Yes.
Yep.
Yes, and Mr. Hewitt maintains that does not mean to say that figure is affecting the tax chargeable for the year of assessment, but I think you say it does.
Yes,
Yeah, right.
yes.
Okay.
That's the nub of the disagreement between us and Section 8.
No, I don't.
Mr. Hewitt, is there anything you want to add in relation to what's been said?
Only that we've dealt with the question about self-assessment accounts in our case.
Yes.
I think it's what the revenue is talking about.
Yes. Thank you very much.
Thank you. Well, as I was saying, thank you both very much indeed for your submissions. Thank you also to all those who were involved in preparing the written cases, which we found helpful. We will consider this matter and let you know our decision in due course. Thank you very much. Court is now adjourned.